The case is now being recorded. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. I'm Justice Henry, and I'm delighted today to be joined by my colleagues, Justice D'Angelo and Justice Hodgens. This is the January 3rd, 2024 sitting of the Appeals Court. We're starting today with one Zoom argument, and then we will transition to the courtroom here in the courthouse for the remaining 5 cases. The we're hearing today on Zoom is docket 2023-P-429, Department of Children and Families, and another versus Father and others. We have Attorney Sherry Krasner for the father. We follow our usual rules even when we're on Zoom, so we have 15 minutes per side, and we will start with Attorney Krasner.
Thank you and good morning, and may it please the court. I'm Sherry Krasner on behalf of Father. My client is viewing this argument on the live stream. My client, an 18-year-old high school student, when he presented himself to DCF, did not do everything that DCF asked him to do. He was a person with flaws. However, because that is all that DCF demonstrated with its evidence, and because that is all that the judge found with her sloppy and imprecise fact-finding, this court cannot affirm. To terminate parental rights permanently and irrevocably demands more. Speaking about my client being a high school student, he was at the time that he presented himself to DCF, not only a high school student, he was involved in high school sports, he was working an overnight job at UPS. In finding 32, the judge said that the first social worker had never seen him act in a lethargic manner. In fact, what that social worker had said, and that's at Record Appendix 3 at page 9, says that the social worker has never seen him not act in a lethargic manner. Given that all that he was doing, really not all that surprising, and certainly not evidence of any drug use, as the judge later goes on to find or to intimate. In fact, a few months after my client presented himself to DCF, an assessment was done. This is in mid-2020. And father was observed to provide appropriate and loving care to the child. He has been able to converse about how he would respond in given situations, yet he was seen as open to education around best practice, as he acknowledged that he was new to caretaking, and he was able to identify positive discipline plans. Father continued to do well during 2020, so much so that sometime, it's not exactly clear in the record, but sometime between December of 2020 and the early part of 2021, he started receiving unsupervised visits. So clearly no safety concerns if the department went on to provide him with unsupervised visits. And at that time, the department also was aware of a charge that was on father's record. There was an open charge at that time of domestic violence. However, that charge got dismissed in January of 2020. So again, even knowing that there was an incident, the department went on to provide him with unsupervised visits, nothing in the record suggesting that his caretaking of his son, his behavior in front of his son, warranted anything other than unsupervised visits.
Counsel, can we clear up something regarding the criminal charges? Because the record is, it's difficult to follow. There were 2 criminal charges. On one of the charges, there were witnesses that saw your client allegedly choke the alleged victim, and your client claims, and I think the witness said that he himself either passed out or doesn't remember. Was that the first charge that was dismissed, or the second charge that was pending during the trial?
I agree with you that it's unclear from the judge's findings, but if you go back, has to do with the first charge and the charge that was ultimately dismissed. The witness was the client's mother, who was not a witness at trial. This is information that she gave to the investigator that the investigator then wrote down. And certainly we know from Luke that that kind of evidence can come in, but it certainly asked the court to acknowledge that. The second charge, which was an open charge at the time of trial, was all we know from the record was that there was that open charge, and we have the Carey explaining that. The DCF had tried to have police records introduced, but father's trial counsel moved to have them excluded, and those records did not come in. Any questions?
I
Please.
was confused though about the timing. Did the second charge occur after the father had completed the online course about domestic violence?
That's not clear from the record. I think the reasonable inference is that it occurred after. The reason I say that is because of the discussions that father had with the social worker, and where the social worker says, well, we'll sort of look for something new. And she sort of didn't do that. That's her language, that she would sort of look for something. And it seems that father did that after that conversation, which suggested it happened after the October 2021 incident. So again, there was that open charge. There was a restraining order in effect. That is what it is, but that's all we know from this record, is that there were open charges and a restraining order.
That was a different victim, right?
Yes, it was. Again, this is not the cleanest record that I've had to deal with, but as best we can tell, that was a different victim. Again, too, so father was permitted to have these unsupervised visits, even though the first charge existed. DCF had no concerns about him. In fact, they also changed the goal. They changed the goal from adoption to reunification. When Miss Brunson came in as the social worker in March of 2021, she changed the visits. They were no longer unsupervised, they were supervised. However, she doesn't say she did this because of any safety concerns or because of father's criminal record. She says that she did it, well, I didn't really know him and I had to assess him. So I switched the visits from supervised to unsupervised. That's at volume 3 of the appendix at page 32.
So you're saying it wasn't because the father had gotten angry at one of the meetings and allegedly made a threat?
That happened. She changed the visits from unsupervised to supervised in March of 2021. The alleged threat happened in January of 2022. What she did at that point, and she wasn't at that meeting where there was an alleged threat. It was a virtual meeting where there was that alleged threat. What she did at that point is she no longer allowed supervised visits to occur in the community. They could only occur at the DCF office. That was the change that she made at that point. But again, never in this case, any safety concerns related to my client's interactions with his child. At all times, he was appropriate with the child. He was loving with the child. Was he late at visits? Yes. Were the visits he had this high school student with the overnight shift had to cancel visits? Yes, but never any safety concerns in terms of what the department was looking for and in terms of any concerns the department might have had with respect to any violent proclivities.
So as I understand the chronology, your client established his paternity, but at that point, the child was already in foster care. Is that right?
The child came into foster care when he was 14 months old. A year later, a trial was set for mother's rights to be terminated. Prior to trial, it was determined that there was no father named on the birth certificate, but prior to trial, the man that she had identified as the father was excluded. My father heard this, it's through the child's godmother. It's not exactly clear how he found out, but he heard that this man had been excluded, or this youngster had been excluded, and he came forward a month before the trial was scheduled to occur. Trial still did go forward with respect to mother, and she did not appear at trial, and her rights were terminated. But father, again, did what DCF asked him to do. He took a nurturing fathers class, and in fact got very high marks from the people who ran that nurturing fathers class. He worked with a parent aide and enjoyed working with that aide so much that he continued to contact him afterwards. Did father have difficulty keeping contact with the foster parents? Yes, he did. We're not going to deny that. But again, that in and of itself is not sufficient reason for terminating his rights. I direct the court's attention to finding 122, which seems to be the judge's summation of father's supposed parental flaws. She says, father has not engaged in individual therapy. That's true. It was never a requirement on any service plan. And there was discussion that he might benefit from him, but I know of no cases that say that something that DCF suggests you do, but isn't on your service plan, that failing to do that should be sufficient to terminate your rights. Judge goes on to say, common purpose terminated him twice, and he never completed the course. That's true. She goes on to say,
So counsel, where I was left though is, are you challenging specific findings of fact that are clearly erroneous? It seemed like from your reply brief, you definitely were.
I am, and although, because over and over, the specific findings are set out in the reply brief, the judge talks about father's failure to engage in the individual therapy, which again, because it was a requirement in his service plan, according to her, that simply wasn't true. She alleges over and over again that he failed to participate in a substance abuse evaluation. That was on one of the 5 service plans that did appear. It is true that he didn't comply with it, but it was only on one service plan. And we know from Leland, and never any suggestion that he wasn't, never any suggestion that he presented under the influence of any substances or alcohol at any visit. And again, we know from
Counsel, didn't one of the social workers make a remark that he appeared high?
Well, she says that in based on some information from February of 2020. This case happened in June. The trial was in June of 2022, and there is never any other suggestion that he was in any way impaired. And if you go back, and that's that same social worker who said that he never didn't appear lethargic. And so it's a little confusing exactly what she is saying. And she doesn't say that she ever observed him. She said there are observations that he was high, or some language to that effect, something that doesn't suggest it was her observation. And even if it were, again, this was in February of 2020, nothing else in the record 2.25 years later suggesting that he was ever impaired by substances at any time when he was with his child, or at any meetings, or in any situation at all in meeting with anyone from DCF or any of the providers that he ever had to deal with during the pendency of the case.
Counsel, was he saying he was ready to walk out of court that day and have the child, or was he saying he needed more time?
He believed he was ready. However, he also acknowledges, and this is in the update to the investigator's report, he acknowledges that there would need to be a transition plan. He acknowledged that the longer this case didn't move forward, that the harder it was on his child. So sort of between a rock and a hard place. Yes, he thought he was competent and fit to parent his child, but he also acknowledged that in order to do that, and he's very cognizant of his child's needs, that some sort of plan would have to be in effect. I see that I just have a matter of seconds remaining, so I'll rest on my brief, and I thank the court.
Well, excellent argument. We understand your position, and now we'll hear from the department. I understand the department and the child are splitting their 15 minutes, and the department has 8 minutes. And I do want to remind folks that this case is impounded, so please stick with child and father so that we don't have any reach of that impoundment.
Good morning. May it please the court, Matthew Price, on behalf of the Department for Children and Families. The department is asking this court to affirm the decision of the lower court that terminated father's parental rights. There was ample evidence of father's unfitness, and the trial court's findings were largely unchallenged. But what this case is about is a father who came forward late, and he was given every opportunity to—
Counsel, can I stop you right there? Because even before you said that, one of my questions is, in your brief, you seem to hold it against the father that he was absent from the child's life for 14 months. But the way I read the record, he didn't know the child was his or had anything to do with the child. So is it fair to really hold that against him when he didn't know the child was his?
I would say yes, but Your Honor, the fact was that he was not present in the child's life when the child most needed him. He came into the child's life late, but he also admitted that he delayed coming forward to the department when he had the opportunity. So he may have not known for a period of time, but there was a period of time that he did know that he still didn't come forward. I wouldn't say
so from DCF's best argument on that, how long would you say the father was out of the child's life when he knew he was the father, or had a strong suspicion, let's say, that he was the father? Best case.
I would say,
because I couldn't find anything in the record of when he found that out and delayed.
Okay, so the child was born in August 2017. The child was removed in October 2018. In June 2019, he's aware that his friend, who could have been, who was thought to be the father initially, was not the father. And I think at that time is when he would have been alerted that he could certainly be the father.
So you want us to make an inference, the fact that his friend isn't the father, that he might realize he's the father, and he delayed coming forward.
I think that the trial court could make the inference of that. I don't think that is exclusively what the unfitness rested on. I think there was a significant amount of other things, but I think that it fell into a pattern of father not being there for his child, even when he did know. He has.
Well, but I want to really join the issue. So the father argues that the judge mistakenly stated 11 times that the father was tasked with undergoing a substance abuse evaluation, and that was not correct. In fact, she says that this task did not appear in 4 of the 5 action plans. What do you say to that?
I would say it's correct that it showed up in the Exhibit 7, which I think is the 3rd action plan. But I think it's important to understand what the action plans are used for. The action plans are, it's a tool that the department uses to assess people and to get to know them. And I think that in this case, it was a good example of how action plans evolved. Father was a stranger to the child when he came into the case, and he was also a stranger to the department. So early on in the action plans, the focus was on visits, developing a relationship between the father and the child, and for the department to assess him as a parent and the qualities and abilities that he had and that he needed. As things developed, particularly by the 3rd action plan, which
Can I stop you right there, counsel? Assess him in his qualities as a parent. Isn't every parent who's never had a child before in the same situation as this father? He's never been a father before, and only because he's late to the game, and I'll grant you he's a little late, you need to assess whether he's going to be an appropriate father. What does that exactly mean in the context of this case, where, as you said, the department's never had any contact with him before, so there's no issue with him in the past. So what does that mean, assess him?
Well, at the time that he came into the case, the child was in the department's custody. Before the department is going to transfer a child to the custody of a parent in this situation, they need to assess and make sure that they're going to be a responsible parent.
So, I understand the department's perspective on this, but isn't that a little backwards? You know nothing about this father, that he's done anything wrong. He's no criminal history at that time, no information, and you're assessing whether he's going to be good for the child. Shouldn't it be, is there anything wrong with him being a father, as opposed to the other way around? Maybe I'm not making it clear, except he's coming into this case as a normal parent who's never had a child before. And you're coming up with a plan as to why he should get the child back. Is that fair?
Yes. The department has a responsibility to make sure that if they're going to transfer custody, they're transferring custody to a responsible parent. Any parent in this situation would go through an assessment process. The department stopped an adoption plan that the child was on to be adopted by the family that he'd lived with for approximately 4 years at that point, in order to give the father a chance to show that he could take custody. And in doing this, the goal changed in his favor to be unified with the child. All he needed to do was really cooperate with the department and show that he would be a responsible parent for the department to change custody. It would be irresponsible for the department to just turn a child over to somebody who showed up late in the child's life without any sort of assessment.
Well, let's put it a different way. If this mother and father were in the hospital, she gives birth, and unfortunately there's a tragedy and she dies during childbirth, he would have just take the baby home, right? Without any involvement of the can take the baby, right?
Yes, and it's in that circumstance, if I understand the question right, the department wouldn't have had custody of the child.
So you're saying that so let's put a different hypothetical in, which is the mother lies about who the father is. The second the father finds out there's a possibility he's the father, he comes forward. You're saying still the department, and let's just assume for a moment that the child is completely a mini-me. This kid looks exactly like the father. And you're saying that the father wouldn't get the child at that point because the department has custody.
If the department has custody, they have a responsibility to ensure that they're transitioning the child into a safe environment with a responsible parent.
Now, just because you're out of time, do you agree that any finding of fact is clearly erroneous?
My argument was that there was only one finding of fact that was considered clearly erroneous, and I would argue that it was not, and it was supported in the record, particularly at the record appendix 3, page 18.
So which finding of fact is that?
128.
And you said record appendix what?
Volume 3, sorry.
Yeah. I just didn't hear you.
Record appendix volume 3, page 18.
Thank you. And you think every other finding of fact is clearly supported?
Yes.
Does
Mrs.
anybody
Henry,
else?
can I ask a follow-up question?
Of course.
Again, in your brief and at least one of the findings of the judge, you cite the father's criminal history and you cite care and protection of Quinn. Isn't it fair that father actually at the time of this trial had no criminal record? Case was dismissed. The first case was dismissed and the second case was pending. It was a charge. So he has no convictions on his record. So why do you say criminal history, criminal record when there is no criminal record?
Well, the judge can review his criminal history as part of evaluating his fitness, and that's what she did. She doesn't need to, it doesn't need to just be a conviction when she's assessing his character, which is part of trying to determine whether he's fit or not. So it's a lower standard that the judge can review. She reviewed the criminal charges, but she also reviewed the circumstances that were in the court investigator's report, which described really violent, at least one really violent crime against a woman that was witnessed by his family, and another which was the open case at the time, which was another violent crime against a woman. So in terms of assessing, it's not just the conviction that the court that is available for the court, because she's reviewing his character and fitness as a parent.
But the second, Attorney Krasner pointed out that there was information about the first charge that was dismissed. So a judge can certainly take those findings or that information in a finding. But on the second case, Attorney Krasner points out that there were no facts in the record of what that was or what the facts were. Is that accurate? Do you agree with her on that?
The facts of the specific incident that took place, I would agree, yes. I think what the judge had before her was the open charge, which included strangulation, and his own father's own testimony about who the victim was, which was his girlfriend or ex-girlfriend at the time. So that was available for the judge to consider and see that there were he had a history of violence against women.
One other question. So Attorney Krasner says that the father was having unsupervised visits and then a new social worker was assigned and then she just decided because she didn't know him to change to supervised visits. Is that what happened? Because that seems very troubling, and I'll just stop it. That seems very troubling if that's what happened.
Well, I think there were concerns about him at that point, and that was part of her judgment.
Well, but I don't think it can be because she was new to him, that she just came onto the case. That seems very wrong, if that's what happened.
Well, I think at that point there had been growing concerns about father and his involvement and how he was passing or not passing the assessment as far as being a fit parent.
And
I
what's
think
your best record citation for that?
I'd have to get back to the court on that.
Okay, I think we'll have to leave it there. Now we'll hear from the attorney for the child, Attorney Kirchway. And I note that in your brief, I think you used the child's first name, and I find that as a recipe for the attorney for the child to say the child's name on the record. So I really wish you would just use child, and I really hope you just use child during your time.
Yes, Your Honor. And in fact, I wasn't the author of that brief. I'm substitute counsel, but Deborah Kirchway for the child. The child does ask you to affirm the decision in all respects. Respectfully, it is not on father to prove his worth as a parent. We know that. The burden is on DCF. And the fact is that while DCF honestly might not have been perfect in this case, there was plenty of evidence that father was unfit. And, you know, first and foremost is the severe domestic violence in this case. He had 2 strangulation charges on 2 different women during the pendency of this case.
So if we had rebuttal, I am sure that Attorney Krasner would argue that the child did not observe any of that, and so we shouldn't consider it. And so I'd like to hear your response to that.
Sure. Well, first of all, the fact that it occurred twice, and the fact that the executive director of Common Purpose indicated that father was at high risk of continuing to make unsafe choices means that that was very likely that it could happen again in the future should child be returned to him. And then at that point, that would be something that the child could be exposed to. And father father claims that the first dismissed charge shouldn't be considered probative evidence of any misconduct. But I would like to clarify that the court can and did consider father's own words to the court investigator from July of 2020. It was not the grandmother who spoke to the court investigator. Well, at least the site I'm looking at was dad telling the court investigator, my mom said I strangled her and I tried to choke her. That's Record Appendix 3, page 13. He said that. So he knows that his mom said that he did that. Now, whether he chose to believe his own mother or not, the fact is he chose not to address this very scary, serious domestic violence. This alone.
I'm gonna pause you here though. Do you think that every factual finding is supported by the record, or do you agree some are clearly erroneous?
I agree. I'll be honest, Your Honor, that was not the focus of my preparation. I never received Attorney Krasner's reply brief, so I'm sorry if that was when contested findings were addressed. So I didn't focus on that because I didn't know that she had addressed any, contested any findings. But I do know that if the claim that there was therapy in the action plans, if that was in the finding, that was erroneous, obviously. But harmless error because the dad admitted in trial that he knew he had been asked many times to attend therapy, and the request for therapy, given father's serious history of domestic violence, was well warranted. And he failed to acknowledge or he not only did he fail to acknowledge the domestic violence, this is a father who couldn't even recall the fact that his own son was very upset at many of the visits. This is a father who is, when he went to the Common Purpose class, he quit because he was no longer interested. He didn't look forward to it. Well, maybe it's not fun to go to a domestic violence class and address your issues, but when you've strangled 2 women, you need to address those issues.
Is there anything in the record that says he strangled the second woman? I hate to keep going back to that, but it's a charge. He's presumed not guilty. There's no fact that I could find in the record as to what he did. So can you point me to where that is in the record?
Your Honor, he did say that he was arrested on those charges. So in order for him to have been arrested, that means that a law enforcement officer had probable cause to believe that he committed a felony, a misdemeanor involving abuse, or an assault and battery. So we do know that. We know that a restraining order was issued, which means that a court found abuse. Is there actual evidence that any other evidence that strangulation occurred? No, I would concede no, but it's serious enough that it needed to be addressed. And father couldn't be bothered to address this very serious issue. He dropped out of the class. He was given multiple opportunities to take the class. He dropped out the first time because he wasn't interested. He dropped out the second time because he wasn't interested. After he was re-referred the second time, he didn't even show up in June of 2021. Then finally he showed up again in August of 2021, and then he dropped out.
He did complete, though, an online 18-hour course, didn't he?
A 16-hour course, Your Honor. He didn't provide us. Yes, he did, but he did not provide a certificate. He, and he couldn't remember the name of the class. He testified about what he learned, and it was pretty minimal, honestly. He said he learned to walk away and to write down some things, which is not evidence of a fully legitimate domestic violence class aimed to address a serious offense. So there are also many.
Why? I mean, he complains and argues that his unsupervised visits with the child turned back to supervised visits merely because the DCF assigned social worker changed, and that there's no other explanation. We hear from the department that maybe there was a growing concern about the department, and that's why the change was, and it was coincidental with the new social worker, but he doesn't have a record citation. Do you know what the situation was?
Great question, Your Honor. And if I could try to respond later by a letter to the court, I would be happy to. I do not know the exact answer. I know that he was very inconsistent with visits. There were periods of time when he was consistent, for sure, but then overall, he was pretty inconsistent. But specifically why it was changed from unsupervised to supervised, I couldn't address that. But other very serious issues of his unfitness were, the goal was changed to reunification in December of 2020. Father was provided with the tools he needed to utilize to achieve reunification. And
Counsel, we're going to have to leave it there.
Okay, and I ask you to affirm. Thank you.
Thank you, everyone. We've very well explained your positions, and we will take the case under advisement. That's the conclusion of the Zoom session. We'll now be moving to the physical courtroom here in the courthouse. Thank you very much.
Thank you.
Thank you.